Good afternoon, ladies and gentlemen of the jury. My name is Randy Chapman, and I represent Bonnie Hicks. This is a matter which occurred almost 2 years ago, and this is Ms. Hicks' first opportunity to present to you what I would suggest to you is evidence that she is not guilty of the offenses as charged. The defendant stands before you cloaked in a presumption of innocence. That's a presumption that the judge will instruct you on, and that presumption of innocence stays with her and doesn't change until the government proves this case beyond a reasonable doubt. And the judge is giving you some preliminary instructions, and they'll be much more in depth later on. I ask throughout the trial, as I know you will, to keep an open mind, to listen to all of the evidence, to place aside any biases or prejudice that you may have regarding the charge itself or the impact or injury that was suffered by John Causland. I ask you to look at all the evidence in its totality, because the Commonwealth has given you a bit of a roadmap, but there will be a lot more. The defendant has no burden to offer any evidence whatsoever, but we fully intend to do so, to give you a much bigger picture than a few seconds of what occurred on November 9th, 2009 at 6:20 in the morning. The evidence will show, when you look at all that evidence, that the government has not sustained its burden, has not proven the defendant drove negligently so as to endanger the safety of the public, or drove under the influence of alcohol. The evidence that we presented to you will show that Ms. Hicks, a woman who works as a billing officer, a billing person in a company, went out that night with a friend. That she had gone to a restaurant, she had a glass of wine. After the glass of wine, they decided to go back to the woman's house. She went back to the woman's house, she stopped on the way, and bought a bottle of wine. Actually 2 bottles, one of which was a present for her friend, and the other for them to share. This is around 10 o'clock at night. She went over the house, she had 2 glasses of wine, and then decided, having already had that other one, that she wasn't going to have any more if she intended to drive home. Her friend had said, "Why don't you have one more and stay the night?" And she stayed the night. She lives in Billerica, she doesn't live in Waltham. She stayed the night, she slept there, went to bed about 12:30, 12:15. Woke up the next morning, she had to get home to take out her dog. She was going to church. She actually works as a custodian at the church, and she also attends this parish. She was driving home, and at this point, it is dark out. And you didn't hear that from the Commonwealth, but the sun didn't rise on that morning until almost 6:50, and it was dark. And as she's driving down Trapello Road, and you'll see, this is a very non-scale diagram, as she's coming down Trapello Road, it will be basically coming down this way. The road actually is 2 lanes that narrow down, or expand down to 3 as you come into this intersection. And she was traveling the speed limit, and there is no allegation offered by the Commonwealth or anybody else that she was not traveling the speed limit of 30 miles an hour. And furthermore, she was driving in her lane as she was driving down to Trapello Road. She was driving fair, she was driving reasonable, she was not driving recklessly. The evidence will show that at this time, at about the same time as she's coming down to the intersection, John Causland, who was 17 years old and apparently worked over at Waltham Crossings, which is this benchmark assisted living, was on the way to work. And he was seen by a woman by the name of Monica LeBlanc, who knows Mr. Causland because she works also with him at Waltham Crossing. And the first time she saw Mr. Causland was when he was running in the intersection, approximately halfway on the road. Mr. Causland was wearing black shoes, black pants, and a black pullover hoodie sweatshirt, and had a Walkman on. And as he's going across the road, running, not walking, running, he did not push the do not walk sign. The green light was clear to Miss Hicks' road. And as she's going down the road, she had the impact. And she said to the police, "I don't know where he came from." And you'll be allowed to draw from your own circumstances. If you've ever been on the road at night, and all of a sudden somebody's there, and you don't even know where they came from. And the indication would be, I will suggest to you, that if you accept Officer Clark's reconstruction, and we're going to offer someone else. I'm going to be bringing in somebody by the name of Steve Benanti, who's the former head of the State Police Accident Reconstruction Unit, who will indicate to you that this was an unavoidable accident from Ms. Hicks' standpoint. What Mr. Clayton indicated was that if she observed at 30 miles an hour him running across this street, she should have been able to stop 59 feet before the accident. That would assume that she was back here, saw immediately a man running across the street in all black at full gait, and if she immediately locked up her brakes, she could stop 60 feet or 59 feet before the accident. If you're traveling 30 miles an hour, the signs will show that you travel 30 feet per second. The difference between this accident occurring and not is 1, 2. That's the Commonwealth's case. That 1, 2, he should have been able to stop his car before he reached her. And what they also didn't tell you and indicate is that they measured a crosswalk that went all the way back here. When in front of this area, if you can measure it back here, because obviously the further of a distance they would say, the more opportunity would have had to see her. But what the evidence will show is that this area, the crosswalk goes back here, is completely invisible to somebody all the way back here. Miss LeBlanc, who was parked over here, who would have had a perfect opportunity to see, didn't see him until he was in the middle of the intersection. And through this way, supposedly, unless she was able to see through this area, through a pedestrian light, through a telephone pole, a little hill here with a bush on the top of it, and you'll see this. You can't say that you start to see him there. It's more up here. And if you actually measure from the point where he actually could see Mr. Causland, you're talking about 2.1 seconds total to have stopped the car, 30 miles an hour. Couldn't have happened. There's nothing, with all due respect to the Commonwealth, with all due respect to John Causland, and I'm sure he suffered an injury, and I'm sure his family has suffered an injury, and I don't deny it, but you need to put aside the prejudice and the bias. I'm going to suggest to you that she is the one that called the police, and she was very upset, and she sounds upset, and you can hear her frantically saying, "Oh my God, oh my God." And the Commonwealth will probably say, well, she sounds kind of slurred. But what's interesting is that Officer Doherty, when he gets there and has a conversation with her, her car is parked in a safe and reasonable way over here with the flashes on. She pulled over correctly. The evidence will show that her speech when Officer Doherty interviewed her was not thick and slurred, and she was not unsteady on her feet. And to add further, there's a videotape of her booking shortly after this incident. And I'm going to suggest to you, ladies and gentlemen, she's standing up just fine. And she does have some health issues, and we're going to offer some medical records that will show that she previously has had a stroke. She's, with all due respect to Ms. Hicks, she's grossly overweight, and that her ability to do field sobriety test is essentially irrelevant, her ability to stand on one leg, given her physical limitations. She told the officers what happened. She cooperated with the officers. She was polite. There is nothing, unfortunately, that can make Mr. Causland any better. But convicting Bonnie Hicks of a crime she did not commit is certainly not one of those things. You will hear, as I understand it, one of the witnesses you'll probably hear from is John Causland and Manny Causland, the father. We are agreeing that he suffered a serious bodily injury. Step back from it dispassionately as you are required to do so, and say to yourself as you hear their testimony, while you might feel great empathy for them and for what has occurred, laying it off onto Bonnie Hicks is not the solution. And I'm going to suggest to you that while you feel the empathy, ask yourself, why am I hearing from this person right now? Does this add anything to the equation of, was my client driving so as to endanger the safety of the public by going 30 miles an hour and staying in her lane? Does it add anything to determine whether or not she was under the influence of alcohol? And if it does not, then with all due respect, you have to move on and look at all the other evidence dispassionately, as I know you will. At the beginning of this case, the clerk swore you in and you took an oath to follow the law, as I know you will. And she stated words that have been uttered in this Commonwealth for the past 200 years. She said, the defendant has placed herself upon her country, which country you are. I am confident at the end of this process that, having heard all of the evidence and keeping an open mind to hearing all of the testimony, that you will be satisfied that the Commonwealth has not sustained its burden of proof beyond a reasonable doubt, and that the defendant stands before you not guilty of the charges. Thank you.
Very good.